for the poor should not be poor legal aid. These were the words of the chairperson of the Delhi High Court Legal Services Committee, an honorable judge who now adorns the bench of the Supreme Court of India, Justice Madan B. Lokur. And these were some of the first words that I heard when I came onto the panel of the Delhi High Court Legal Services Committee. And these words have stayed with me ever since. Legal aid for the poor should not be poor legal aid. In the system of justice that we have set up for ourselves, namely the adversarial system of justice, where cases are decided on an A versus B basis, effective legal representation is an absolute must. It's a sine qua non for effective dispensation of justice. Let us disabuse ourselves of one basic doubt or impression that we carry, that legal aid is something that we give to a poor accused. Let us disabuse ourselves of that notion. Legal aid is something that the system requires. Legal aid is something you give to yourself as part of the legal system in our country. The very credibility and the integrity of an adversarial system of justice depends on two sides canvassing their viewpoint, and in order for that to happen effectively, it is absolutely necessary. It is necessary for the efficacy of the system itself, for the sanctity of the system itself, that there should be effective legal aid provided to anybody who cannot afford it himself or herself. It is for this reason that at the time of drafting the Constitution itself, the basis for legal aid was laid by the Constitution makers in the chapter relating to fundamental rights. Therefore, Article 21, the right not to be deprived of one's life or personal liberty without, except in accordance with law. Therefore, Article 22, the right to consult and to be defended by a legal practitioner of one's choice. And the same was reflected in subsequent amendments, notably in Article 39A, which makes it very clear that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disability. So the words are by reason of economic or other disability. The same philosophy finds reference in the Criminal Procedure Code in section 304, which provides for legal aid to an accused at state expense. Now, as Article 39A says, two of the most significant factors that weigh against our justice system are illiteracy and poverty. Illiteracy because of necessity, naturally. Illiteracy brings a certain element of ignorance in matters relating to one's rights, one's position in society, one's position in front of a judge. So, by reason of illiteracy, people really don't know where they stand in the system. The second aspect is poverty, because no matter what we say, whether we like it or not, our system simply cannot function without at least some money. Whether it is money by way of payment of requirement to pay court fee, whether it is money to pay the professional fee of a lawyer, whether it is to furnish a surety in the instance of bail, for example. Without money, nothing will work in the system. Now, in my view, in my perspective, legal aid really endeavors to solve these two problems: the lack of information and the lack of means. Now, where does legal aid begin? In D.K. Basu, the Supreme Court had in fact laying down the precepts, the principles governing arrest, and what are the steps to be taken at the time of arrest. One of the things that the Supreme Court said was also that the arrestee may be permitted to meet his lawyer during interrogation, though not throughout the interrogation. Now this was way back in 1997. Today, however, there appears to be a shift in the position as to where legal aid begins, because, among others, of one of the most recent judgments of the Supreme Court in the case of Kasser. In deciding the appeal by Kasser against the sentence awarded to him by their judgment of 29th August 2012, the Supreme Court has, in my view, digressed or deviated from the position under D.K. Basu 1997. And I think it would be useful if you permit me to read some portions of the judgment of the Supreme Court in Kasser's case. I would refer first to paragraph 484 of the judgment, where the Honorable Court says, "We therefore have no hesitation in holding that the right to access to legal aid, to consult and to be defended by a legal practitioner arises when a person arrested in connection with a cognizable offence is first produced before a magistrate. We accordingly hold that it is the duty and obligation of the magistrate before whom a person accused of committing a cognizable offence is first produced to make him fully aware that it is his right to consult and to be defended by a legal practitioner, and in case he has no means to engage a lawyer of his choice, that one would be provided to him from legal aid at the expense of the state. We accordingly direct all magistrates in the country to faithfully discharge the aforesaid duty and obligation, and further make it clear that any failure to fully discharge the duty would amount to dereliction in duty and would make the concerned magistrate liable to departmental proceedings." So today it is the bounden duty and responsibility of every magistrate before whom an accused is produced to inform him of his legal rights and to tell him that if he can't afford a lawyer, he will be given one at the state expense. But what the Supreme Court is also saying is that the right to access to legal aid actually begins when the person is produced before a magistrate. The court goes on to say, it needs to be clarified here that the right to consult and be defended by a legal practitioner is not to be construed as sanctioning or permitting the presence of a lawyer during police interrogation. According to our system of law, the role of a lawyer is mainly focused on court proceedings. The Supreme Court says the role of a lawyer is focused on court proceedings. The accused would need a lawyer to resist remand to police or judicial custody, and for granting bail, to clearly explain to him the legal consequences in case he intended to make a confessional statement, to represent him when court examines the charge sheet and decides about the future course of proceedings, and at the stage of framing of charges, and beyond that, of course, for the trial. And then the Supreme Court distinguishes, saying that these rights in the Indian context do not arise from the Miranda principles, the case of Miranda versus Arizona in the US, but the right to access a lawyer is for very Indian reasons. It flows from the provision of the Constitution and the statutes, and it is only intended to ensure that those provisions are faithfully adhered to in practice. And then the Supreme Court goes on to say that if legal representation is denied at the trial stage, it would vitiate the trial, but if it is denied at the pre-trial stage, then the consequences we will have to see. It says it would not vitiate the trial unless it is shown that failure to provide legal assistance at the pre-trial stage had resulted in some material prejudice to the accused in the course of the trial. This, therefore, my friends, is the position in regard to when legal aid begins, when the right to legal aid begins. This is the law of the land. This is the verdict of the Supreme Court. I am in respectful disagreement with what the Honorable Court has ruled. We are all too aware, people amongst us who have dealt with the criminal branch of the law, who have represented people whether at the trial stage or the appellate stage. The worst basis that is laid to any criminal proceeding is in the police station, when a person is first arrested. It is a myth to think that immediately upon arrest, the police officer picks up the CRPC, opens it and goes one step at a time, scrupulously following the provisions of the procedure as laid down in criminal jurisprudence. It is a complete myth. How many of us have seen papers, and I practice essentially in the High Court of Delhi, and therefore what passes through my hands are essentially appeals, very serious murders, rapes, double murders, whatever. But in every case, this thread of paperwork being conducted in a police station, paperwork being conducted by getting accused or arrested persons to just sign blank sheets and then being filled up, of interpolations being made, of witnesses being added later on. This is something which is the most common thread that runs through all criminal proceedings in our country. And once the fundamentals, the foundation, the basis of a criminal matter, of a criminal proceedings is laid in this fashion, it is a foregone conclusion as to what will become of justice in that matter. And therefore, it is my respectful submission, and I think at some appropriate stage we need to request, we need to urge the Honorable Supreme Court to review what has been said in Kasab's case, that legal aid must of necessity begin at the moment the person is arrested. There are innumerable cases. In Delhi, I do not even venture to think what would be happening in far-flung areas which are distant from the power centers, and what would be happening in a police station when people are just taken in and then locked up without any questions or answers being given, any questions being asked or answers being given for days on end. DK Basu is violated. Nobody is informed that their husband or son or wife or anybody is in police custody. Arrests are shown whenever the police deems it appropriate. Therefore, to say that legal aid, actually the right to legal aid begins when a person is first produced before a magistrate, gives a complete carte blanche. It gives an open hand to the police to do what they like with an arrestee before he is produced before a magistrate. Now, as far as the Delhi Legal Services Authority, and in particular the Delhi High Court Legal Services Committee is concerned, having been set up